So we have an update in the current assault weapon ban challenge that is up for Supreme Court review. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Brownells. Brownells is an amazing company. A lot of you guys know Brownells. You purchase things from Brownells. They're pro 2A. They're great people. I got to spend some time with them out in Grinnell, Iowa. Again, amazing people. An amazing facility out there. They have great products. You know, the prices are amazing. So if you're interested, go over, check out Brownells. And if you use the code SCHOLAR10, you can get 10% off of your order. Also want to thank everybody who on the last video liked, commented, and subscribed. You know, I kind of wanted to do a test. It seemed like a lot of you guys did do that. You commented and liked. So again, thank you guys. And also on this video, if you guys just like the video, comment, even if it's just to fuel Al Gore's rhythm, that really does help these videos to grow and to get out to more people. Now, as I mentioned in the intro, in this video, we're going to be talking about how an assault weapon ban case is currently seeking Supreme Court review, and we just got an order from the Supreme Court. In this video, we're going to be discussing the Maryland assault weapon ban challenge case, which is the Bianchi versus Brown case, also known as Snope versus Brown. Recently, we received a decision from the Fourth Circuit en banc panel, which upheld the state of Maryland's ban on so-called assault weapons. The Fourth Circuit en banc panel stuck to the position that these types of rifles are useful in military service, that they are militaristic weapons, and because of that, the state can ban them as dangerous and unusual items, or dangerous and unusual arms, and they claim that these types of weapons, these arms, are not protected by the Second Amendment. Now, although we lost that in the Fourth Circuit en banc panel, now this case is in front of the Supreme Court, seeking review from the Supreme Court, and it's on a final merits, which is what the Supreme Court has been asking for a long time. However, as always, like I mentioned in the last video, the anti-gunners in the state here are trying to delay and stall this case as much as possible, and they had requested for a second delay of review in this case. But now we got an order on that request from the Supreme Court, and the Supreme Court has partially granted a delay, but it has not been a complete win for the state of Maryland. Instead, what this order indicates is that the Supreme Court is wanting to review this issue, take it for conference potentially before the end of this year. Now, for those not aware, this case involves the state of Maryland defining certain firearms, certain rifles as so-called assault weapons and therefore banning them. This ban was challenged in a federal district court in Maryland. However, this case was then dismissed by a lower court because there was already a case on the books that found that this Maryland ban did not violate the Second Amendment. That prior case was called Colby, and it was ruled on by a prior Fourth Circuit en banc panel. This case, Snope had to concede that the Colby case was controlling precedent, but they claimed that it was incorrect and that the court should reverse that decision. Now, that dismissal then went up to the Fourth Circuit. It was appealed. The Fourth Circuit agreed and dismissed the case, and then this case made its way to the Supreme Court for the first time back in 2022. The Snope case sat on hold behind the Bruin case, and after the Supreme Court issued their 6-3 decision in Bruin, they then granted, vacated, and remanded the Snope case back down to the Fourth Circuit for a new decision in light of Bruin. The Snope case then was opened back up. A 3-judge panel back in December of 2022 heard arguments in this case, but then the Snope case sat silent and dormant for 13 months. So even back in 2022 on, there was a 13-month delay in this case. And that was because the Fourth Circuit did not want a pro 2A decision to be coming out of their circuit. And then ultimately what ended up happening is the Fourth Circuit en banc panel took this case out of the hands of that lower court. And ultimately then they issued their own decision upholding this rifle ban, finding that it did not violate the Second Amendment. Now, although that was the opinion of the majority, there were dissents by Judges Richardson, Niemeyer, Agee, Quattlebaum, and Rushing, who did not agree with their other colleagues in the Fourth Circuit, and essentially they were stating that their colleagues were just outright defying what the Supreme Court said in Bruin, and they were doing everything they could to not protect the Second Amendment. Now, the dissent in their opinion states that the majority decides that Maryland's ban is perfectly consistent with the Second Amendment, but the majority's rationale disregards the Second Amendment and controlling precedent. Rather than considering the amendment's plain text, the majority sidesteps it altogether and concocts a threshold inquiry divorced from the right's historic scope. To make matters worse, it then misconstrues the nature of the banned weapons to demean their lawful functions and exaggerate their unlawful uses. So the Fourth Circuit there is just pointing out that their colleagues are doing what we all knew they were going to do. They were going to violate the Bruin decision, they were going to violate the Second Amendment, and they were going to come to an anti-gun decision. Now, after that terrible Fourth Circuit decision that cleared the path to go to the Supreme Court with a rifle ban case on a final merits issue, and that's exactly what is now happening in this case. The plaintiffs have now submitted to the Supreme Court a cert petition asking for the Supreme Court to finally address this issue. Originally, the state of Maryland, who are the defendants, were supposed to respond to the petition on September 23rd, but now the state has asked multiple times to have a delay on them filing their response. In the first letter that they submitted to the Supreme Court asking for 30 days, they stated that the extension is necessary because of the press of other assigned work. Notably, undersigned counsel and others associated with this case are involved in matters relating to the collapse of the Francis Scott Key Bridge in Baltimore, as well as other ongoing Second Amendment litigation. The other litigation that they're pointing to, which is 2A litigation, is the Maryland shall issue lawsuit. And so they are also having to address that. But also interesting with that, they haven't even responded to that petition in the Maryland shall issue case. They haven't sought an extension in that case. But for some reason in this case here, dealing with the rifle ban, they have asked for one 30-day extension, then another 30-day extension. And so it's just kind of interesting that they are running with that narrative. Now, with the original 30-day extension, there was no opposition to that. Happens all the time. Attorneys agree to, give additional time. But now the Maryland Attorney General had asked for a second delay. They wanted another 30-day delay related to them having to address the bridge issue in Baltimore and the other case that they were dealing with, which was another 2A case, the Maryland shall issue case. And so they were saying that they needed 30 more days. And so what's important about that is, if granted by the Supreme Court, that would push out the potential conference for this case out to next year, 2025, which would push out any potential hearing, briefings, and potential decision from the Supreme Court even further. Now, there's a lot of reasons why the state here would want to do that. Maybe they're just trying to wait until after the election. Maybe hope that if they push it out to next year, if they got a president that they favor, maybe Kamala Harris, maybe Harris would have the opportunity to put new judges on the Supreme Court, new justices on the Supreme Court, and then that would kind of shift the power in the Supreme Court to maybe be in favor of something like a rifle ban. So there's a lot of reasons why Maryland might have done this, but they were trying to delay this case at the very least. The plaintiffs in this lawsuit opposed this second request for a 30-day extension. They stated in their letter that we filed the petition for writ of cert just 15 days after the Fourth Circuit issued their decision below. As the deadlines in this case currently stand, and after the respondents already received an initial 30-day extension to which we did not object, this case will be distributed on November 6, 2024, and will be considered by the court for the first time on November 22, 2024's conference. With just 3 conferences remaining before the end of this year, a 30-day extension would mean that this court would not consider this case at conference until January 10, 2025. And in opposition to this, the plaintiffs then requested that at the very least, the Supreme Court should not grant anything beyond a 13-day delay in this case. And now we got an order from the Supreme Court. The Supreme Court has agreed to partially grant the extension of time and simply delay it only for the 13 days. And that means that the Supreme Court has recognized that this is an important issue, that they potentially also want to hold conference on this case before the end of this year. So that would mean that it would be distributed like the plaintiffs wanted by November 19th of this year and potentially considered at the first conference on December 6th, 2024. So before the end of this year, this case could be in front of the Supreme Court for consideration, and then it would be up to the Supreme Court if they want to grant review to this case, grant the cert, and hear it this term. So this is a very important battle. It seems like we got a slight win here. Maryland was trying to delay this as long as possible. They wanted to push it out into next year, but here we got a slight win. And this also just kind of illuminates that this is on the minds of the Supreme Court. The Supreme Court is considering this. They potentially want to address this. At least they want to have this in their hands before the end of this year. So I wanted to give you guys that update because of the last video, and that's what's currently happening with this critical case challenging a state's ban on so-called assault weapons. And now we're going to wait to see what the Supreme Court does. We're going to wait for that response from the state of Maryland, and then we're going to also wait for the conference and see what maybe comes out of that. So if anything else changes, if we get any more news, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.